Estelle Griswold, the executive director of Planned Parenthood League of Connecticut, and Dr. C. Lee Bruxton, a gynecologist studying at Yale University, were arrested and fined $100 each for aiding and abetting contraceptive use, according to an 1879 Connecticut state law. This law banned any use of drugs, medical advice, or instruments to prevent contraception. This law states any person who uses any drug, medicinal article, or instrument for the purposes of preventing contraception shall be fined not less than $40 or imprisoned not less than 60 days. It also stated that any person who assisted, abets, counsels, causes, hires, or commands another to commit any offense may be persecuted and punished as if he were the principal offender. At the time, only Connecticut and Massachusetts obtained a law banning any use of contraceptives since their state governments were trying to enforce Protestant morality. What year was the law created that banned contraceptives? Griswold and Buxton violated a Connecticut state law that banned the use of any drug, medical advice, or instrument. Connecticut state legislature believed that they had a legitimate role in regulating birth control devices and information as a way to prevent adultery and uphold public morality. Prospector Joseph B. Clark defended the state legislature, stating that married couples can still practice birth control through abstinence, withdrawal, and the rhythm method, as they are legal for married couples in Connecticut.
Griswold and Buxton claimed that the 1879 Connecticut state law violated the Due Process Clause and Equal Protection Clause of the 14th Amendment. This is because laws against the use of contraceptives historically inhibited healthcare in the lower class when compared to the upper class. Why did Griswold argue that the 1879 Connecticut state law violated the Equal Protection Clause of the 14th Amendment? The ruling was 7-2 towards Griswold. The Chief Justice was Earl Warren, and the writer was Justice William O. Douglas. The court ruled that the Constitution did protect the right of marital privacy against state restrictions. The Constitution does not explicitly protect a general right to privacy, but the First Amendment, Third Amendment, Fifth Amendment, and Ninth Amendment is applied against the states via the 14th Amendment, which creates a right to privacy that cannot be unduly infringed. Although this was written by Justice William O. Douglas, there were many disagreements where the Constitution applied fundamental rights. For instance, Justice Arthur Goldberg argued that the Ninth Amendment, which states that the Bill of Rights does not explicitly state all the rights of the people, implies that citizens of the United States have the fundamental right to marital privacy. Another example would be Justice Byron White, explaining that a right to marital privacy is implied under the Due Process Clause, which is protected by the 14th Amendment against the states.
What did Justice Byron White argue where the right to marital privacy is located in the Constitution? The significance of this court case was that a married couple has a right to privacy that cannot be infringed upon by a state law, making it a crime to use contraceptives. However, this was only established for married couples, but paved the way for legalization of birth control for all people in the Eisenstadt v. Baird court case. This also helped support and establish Roe v. Wade, access to safe and legal abortion. Contraception helps keep more women and babies safe from potentially harmful and unwanted pregnancies. In 1965, 32 women out of 100,000 births died, and today the rate is less than half of that. Infant mortality went from 25 deaths to 6 deaths out of 1,000 births. Birth control has also helped people for non-pregnancy related situations like acne, cramps, and endometriosis. Which two court cases did Griswold v. Connecticut lay a foundation for?